My name is Tony Vernetti, and I am the president and founder of F.E.D.S, Federal Employee Defense Services, which provides professional liability insurance to federal employees. I want to thank you for attending today's webcast on federal employee professional liability insurance. Before we get started, just a little bit information about myself. I am a former federal attorney. I worked at a federal law enforcement agency for several years, and then I practiced law at the Washington, D.C. law firm of Shaw, Bransford, and Roth, where I defended federal officials at a variety of federal agencies. Today, it's our hope that you will learn about your administrative, civil, and criminal exposures that you face as a federal employee and about the professional and financial risks associated with your federal position, and how professional liability insurance works and the coverage it provides. The liability exposure for all federal employees really began back in June of 1971 with this Supreme Court decision known as Bivens versus 6 unknown federal narcotics agents. This decision was the very first time the Supreme Court decided and allowed federal employees to be held personally liable for simply doing their job. This is not law school, so I'm not going to get into the complex legal analysis in this case or really the facts at all. All you really need to know is that federal employees can be sued personally and can be held liable for monetary damages. You don't have absolute immunity for these types of lawsuits. These are what we call personal capacity lawsuits. You do have qualified immunity, I should mention, and that's pretty darn good because that means you will not be held liable if your actions were legal and you had a belief, you had a good faith belief that your actions were legal and your belief was a reasonable one. But because there is this possibility, and it does happen, that federal officials could be liable for simply doing his or her job, the idea for professional liability insurance came about. And it was then later expanded to cover attorney's fees for investigations, disciplinary actions, and criminal cases, and we'll get into a lot of that here today. In response to this decision, Congress passed a law that requires federal agencies to reimburse managers, supervisors, and law enforcement officers up to 1/2 of the cost of the professional liability insurance. Okay, this is a very important point because Congress understands that you need this protection and they want to share the burden of the cost with you. Can't emphasize this point enough. Congress really appreciates that you need this kind of protection to have peace of mind to do your job. So they want you to get the protection that you need. Given the enormous responsibility of the federal government, it's virtually impossible for us to identify each and every position. But if we had to, these are the categories where people enjoy the most exposure. You know, obviously, if you're protecting our nation's security, you work at one of the intelligence agency, anybody in federal law enforcement. If you're a manager managing employees, you're vulnerable to employee-type complaints. You know, anybody who's making decisions on public policy or the interests of the public have vulnerability. Certainly those who provide medical or financial services, COTARs, contracting officers, and if you're regulating any products or businesses, security matters, things that are affecting the public, you can be vulnerable to complaints. These are just some of the federal employee positions that we've identified along the way as to having, exposure and needing professional liability insurance. As I said, it's impossible to identify every possible scenario and position in the federal government that has liability exposure. However, it's our hope today that once you get this information, that you will be able to identify your own exposure, your own type of risk within your federal position. You want to think of professional liability insurance in terms of 3 categories. Those 3 categories I mentioned at the start of the presentation today: civil, administrative, or disciplinary, and criminal. The PLI, or professional liability insurance, provides defense and indemnity protection in these work-related civil lawsuits, any administrative matter or disciplinary matter, and any criminal investigation. Now, depending upon the nature of your work, your primary liability exposure really may be different. Those who protect our nation's security or work in intelligence community may be primarily concerned with civil or criminal exposure. The same is true for those in federal law enforcement or security. Those who manage or supervise federal employees, make decisions on public policy or in the interest of the public, medical folks, financial folks, you may be primarily concerned with administrative type investigations. We're going to start out with civil exposures. As I mentioned, these are referred to as personal capacity, individual capacity lawsuits. You'll hear them called Bivens actions, constitutional torts, and like I said before, they involve some very complicated legal principles. But for purposes of today's discussion, what I want you to take away is an understanding that you can be denied DOJ representation. Well, the first appreciation is that you can be sued. If you are sued, you're going to want to know who's going to represent you. Usually it's DOJ, Department of Justice, but you can be denied DOJ representation. And you can be held personally liable even if DOJ represents you and they lose. You don't have absolute immunity for these types of personal capacity lawsuits like you do for lawsuits under the Federal Tort Claims Act. The response I get frequently when I go around lecturing on this topic is, I'm okay. I'm told that I'm okay. I'm protected as long as I'm acting within the scope of my employment. That's not necessarily true. Even though you're in the scope of your employment, it's a two-part test that DOJ has to address to determine whether they're going to represent you. Are you in the scope, and then is it in the interest of the United States to represent you? Okay? DOJ representation is not mandatory, and it's not automatic. So if they say, no, it is not in the interest of the United States to represent you, and you don't have liability insurance, while you may be able to assert qualified immunity and these other beautiful immunity doctrines, you're going to be on your own to hire legal counsel to provide that defense for you. If you had a F.E.D.S professional liability insurance policy, we would appoint counsel for you. When does this happen? When does DOJ say it's not in the interest of the United States to represent you? This most often happens if you're being investigated for some sort of wrongdoing for the very same reason that you were being sued. You can see that Department of Justice will not want to be on both sides of that. A F.E.D.S policy may also appoint what's called coverage counsel to monitor Department of Justice defense of you, because again, after all, even if they're defending you, if there is a judgment against you, it is your personal liability if your agency refuses to indemnify you. We also may appoint coverage counsel if DOJ is on the fence as to whether they will represent you or not. We may appoint coverage counsel to go in there and convince them that it is in the interest of the United States to actually provide you representation. And finally, as I mentioned, the F.E.D.S policy provides for indemnification up to $1 million or $2 million to pay any judgment if you're found liable and your agency denies indemnification, and that money is also there to settle any particular egregious case. Here are some real-world examples of lawsuits against federal officials. Just give you a second to look those over. So just a real quick recap on civil liability. What I want you to take away is that you can be sued, you can be denied DOJ rep, and you can be held liable for a judgment. Liability insurance protects you in these three major ways. It provides legal defense, coverage counsel, and it pays damages. A final point that I want to make before we leave civil here is that a civil lawsuit without Department of Justice representation is rare, okay? With actual liability being even rarer. It's probably less than 5% of the cases. In fact, if you've ever attended one of your agency's seminars on employee professional liability, sometimes the lawyer given the presentation may advise against buying professional liability insurance, saying the risks are relatively low that you'll be sued without DOJ rep and actually found liable. And this is how they approach it from this civil liability exposure. Nevertheless, it does happen, so no matter what the percentages are, why would you risk it if you can insure it away for less than $200, which you'll find out today? That's what you can do. You'll spend more for 1 hour of legal services than you will for what the annual premium costs. More importantly, most employees, their real bang for their buck with liability insurance is for these administrative protections, for coverage for administrative matters. This is the real value sometimes with the liability insurance. So the administrative provision of the policy covers all these types of inquiries or investigations. You know, any administrative investigation, you'll have a paid legal defense up to $200,000 for any administrative matter that could result in a personnel action against you. Whether it's an OIG, Office of Inspector General, OSC, Office of Special Counsel, Congressional, HR, EEO, or any internal management investigation, the Fed's policy will provide an attorney throughout the investigation, and in the unfortunate event that there is a disciplinary action imposed against you, the Fed's policy will provide an attorney to defend both at the agency level and at the Merit Systems Protection Board if necessary. I should also mention that for other professionals, administrative protections such as for lawyers, doctors, other medical professionals, that the protections also provide for a legal defense for any response to a professional licensing entity. So the medical boards, your state bar, if you're a lawyer, state bar proceedings, veterinary and medical boards. Anything that arises out of your employment that gets reported to one of these boards regarding your licenses will provide a defense for that as well. I have found that federal employees sometimes do not appreciate the seriousness of some of these investigations. What you need to understand these days is that whether your actions are intentional, unintentional, the name of the game is accountability, okay? And you can be sure the agency will be looking to hold folks accountable for even the most trivial violations of agency policy. It's simply allegations of wrongdoing or simply the cost of doing business these days. Complaints can be made by anyone, members of the public, Congress, disgruntled employees. And whether they're true or not, most agencies are required to determine the validity of the allegations, which is always going to begin with an investigation. If you're involved with something that involves fire, injury, death, monetary loss, anything that gets media sensation, negative public impact, there are political agendas, you can bet your bottom dollar that you'll be subjected to an investigation. So what the Fed's policy provides is obviously a defense against any of these types of allegations. It will prepare you for the agency administrative and investigative process, actually attend the investigative interview with you if the lawyers are permitted, which they are in a lot of investigative cases. It's not an absolute right, but most investigative bodies allow your representatives in as a courtesy. And then obviously we will defend in any resulting disciplinary action, as I mentioned, both at the agency level and at the MSPB. I want to take a little bit of information, little time here to talk a little bit about the Office of Inspector General or the IG. I can't tell you how many times I have heard people say, in response to being notified that they are a subject of an IG investigation that, look, I didn't do anything wrong, and if I did, I could surely just walk down there and explain it to them. Or if I show up with a lawyer, they'll think I'm guilty. The IG, which most federal agencies have, there are something like 26 statutory IGs, investigate or tasked with their agency's watchdog. They investigate fraud, waste, and abuse, and more importantly for our discussion, employee misconduct. And believe me, they like making cases against federal officials. It's not to say their role in the government is not very important. It's just that I've seen a trend at them trying to make cases at all costs, you know, and investigating matters that are above and beyond the original allegations. So when the weight of the federal government, the weight of the IG is on you, the magnifying glass, the microscope, I'm here to tell you none of us are perfect. So you want to make sure that you take these IG investigations very seriously and get the legal advice that you need. Those who, you know, who I said before, I didn't do anything wrong, and if I did, I can explain. You know, or I can't go up with a lawyer, or I can't talk to a lawyer. They're going to think I'm guilty. People who implement those kinds of concepts on their own without getting legal advice typically do not fare well. You want to at least talk to an attorney if you are the subject of an IG investigation, if for nothing else to understand what your rights are, okay? Not every request for an interview is mandatory. Often they are voluntary. And submitting to a voluntary interview with the IG is a waiver of your Fifth Amendment right to silence, which is something you should never do without talking to an attorney. The thing to appreciate about the IG is that they are criminal investigators, okay? Even though they may be looking at administrative employee misconduct, in your case, they are criminal investigators first, so they're going to look at it from that angle first. And there is very little you can do wrong in the federal government and not also have it be a violation of Title 18, which is the criminal code. So before you sit down with any IG investigator, please make sure that you at least talk to an attorney. The same goes true for the Office of Special Counsel. OSC is an independent, what I call a quasi-prosecutorial agency that's going to investigate prohibited personnel practices, whistleblower reprisal, prohibited personnel practices are things like pre-selection in the hiring process, nepotism, showing preferences, reprising against federal employees who have engaged in what's called protected whistleblowing. So these OSC investigators will come into your agency and investigate. And again, you're allowed to have a lawyer during the interview, so it's important to get legal advice if you are the subject of one of these types of investigations. Congressional inquiries are another type of investigation that you could be subjected to. Often it can come from informal requests for testimony as opposed to a formal subpoena. We've seen a trend in the politicals serving up the career officials to go testify in Congress when there is alleged agency wrongdoing. So you want to make sure that you get the proper legal advice if you are being told that you are the subject or congressional testimony is required of you. And if a disciplinary action could flow from this congressional oversight, the Fed's policy, will you appoint your own lawyer to monitor the congressional investigation and actually attend any investigative interview with you. This also extends to any congressional commissions, such as the 9/11 Commission, or the types of commissions where Congress forms in order to look at specific matters. EEO complaints. I'm often asked, why do I need liability protection? Why do I need my own lawyer for an EEO complaint? Isn't it a case filed against the agency? You know, I realize I'm the responsible management official, but isn't an EEO case against the agency? That's true, and you cannot be held liable if the agency loses the EEO case, but you can be disciplined, okay? And the agency lawyers, while they're responsible for defending the EEO case, And often your interest as the manager and the agencies and the agency lawyers, often those interests are aligned. But the agency lawyer's client is the agency. Their duty of loyalty is to the agency. So they could be advancing an interest that's adverse to yours. So it's important sometimes to have your own counsel looking out for your interests. Moreover, I have found that the agency is not terribly good at explaining to managers what their role is in this process, okay, where you fit, what you're supposed to be doing. It's your job to establish what's called the legitimate non-discriminatory reason for doing whatever it is you did or did not do that that employee is suing over. And that's often done and established by your initial affidavit during the investigative phase of the EEO complaint. So we'll appoint counsel to assist with that affidavit, which is establishing your legitimate non-discriminatory reason at a very early stage as opposed to at the trial doorstep or on the steps of the courthouse. Here are some real-world examples of administrative actions. I'll just give you a second to take a look at that. And as you're looking at that, the one thing I would like to emphasize about what the liability insurance covers is that you can see, if you look, when you look at all these examples, that everyone's involved in doing their job, okay? That the allegations must flow out of you rendering a professional service, scope of employment, doing your job, not, let's say, if you engaged in some sort of off-duty misconduct, or maybe you were arrested for something, you know, or something happened totally outside the scope of your employment, the liability, even though it may have an impact to your federal position, it still may have a nexus, okay? You are not going to be covered by the liability insurance. It must flow from you rendering a professional service. Finally, and quickly, I want to talk about your criminal exposures. I know most of you did not come to work today, your federal job, to commit a federal crime. But as federal officials, you need to appreciate that there is very little you can do wrong in the federal government and not also have it be a violation of the criminal code, as I mentioned before. Some of the most common criminal investigations involve federal managers, federal employees, law enforcement, conflict of interest statutes, you know, where intent is not a prerequisite to prove the crime. Misappropriation of federal funds, release of Privacy Act or other statutorily protected information, any situation arising out of the alleged, you know, misuse of position or authority. If you are notified that you are a criminal investigation, the same like I said about the Office of Inspector General investigation, it is absolutely important for you to talk to or retain a criminal defense attorney before you talk to anyone, okay? And you also do not have the luxury as a federal official to sit around and see if an indictment is going to come, okay? Because if an indictment comes, it's game over. The agency is going to put you on indefinite suspension without pay pending the conclusion of that criminal matter. You need an active criminal defense counsel working the investigative entity to convince them to decline what's called a declination of prosecution, okay? And sometimes we'll see a criminal investigation run parallel to an administrative type investigation, and that's going to involve some very complicated constitutional issues about who you should talk to, when you should talk to anyone. So if the matter for which you are being criminally investigated for involves you rendering professional service with your job, the Fed's policy will provide you an attorney to defend. Here are some real-world cases that resulted in criminal investigations against federal officials. Give you a moment to take a look at those. Okay, this is just a recap of what the policy, the F.E.D.S professional liability insurance policy covers. Again, it covers up to $200,000 for attorney's fees for any administrative or disciplinary matter, provides up to $1 million or $2 million of indemnity protection, provides attorney's fees up to the $1 or $2 million limit to defend the lawsuit if the Department of Justice declines representation. And that's an important distinction between us and some other policies out there. We give you the full $1 or $2 million limit for attorney's fees as well. It's just all in one big bucket. Other policies will cap your legal defense at the $200,000 limit that the administrative provision provides. And then finally, the $100,000 to defend in any criminal proceeding. Some other important policy features I should mention is for no additional costs, because other policies will charge extra for these things. The policy covers you anywhere in the world, again, at no additional cost. So if you're stationed outside of the U.S., CONUS, whatever, you are still protected as long as the allegations involve you performing your professional functions. The policy provides 2 free legal consultations for pre-complaint matters or other matters outside the scope of the coverage, again, at no additional cost. There are no deductibles to filing a claim. Our benefits are secured by a U.S.-based insurance company with an AM Best financial rating of A. And finally, the F.E.D.S policy provides for a free 3-year tail for civil lawsuits after you leave federal service. So you will be covered for 36 months, which is standard statute of limitations for any type of lawsuit that could be filed against you, and you don't have to buy the insurance each year. You're just automatically covered. I have been defending federal employees for many years now, and I founded F.E.D.S with the intent to provide education, protect hardworking civil servants, and I'm here to tell you that if the complaint comes from a member of the public, special interest group, industry, politically motivated elected officials, or even a subordinate employee, the thought that an investigation requiring legal counsel could never happen to you is naive, okay? I can't tell you how many people that I represented that had to spend $25,000, $50,000, $100,000 of their own money to defend against an agency action. Had to bleed out their TSP, had to get second and third mortgages on their home, that if they just would have spent the few $100s that a liability insurance policy costs, they would have been fully covered, okay? Even if you're ultimately vindicated of the allegations made against you, at $400 an hour, the costs are going to rack up very, very quickly. So you want to make sure that you evaluate whether you need liability insurance, because as you see here, you do not have to break open the piggy bank in order to get it. The coverage is only $290 for the $1 million, $3 for the $2 million, and if you're eligible for the reimbursement, it's as little as $145 annually. Okay, think about what you spend, a few $100s on these days. We also have payroll deduction available that starts at $12 per pay period. Again, with hourly rates running $300 to $400 an hour for experienced lawyers in federal personnel law, you're going to pay more for 1 hour of legal service than you are for what the annual premium costs. This final slide, I can't emphasize this point enough, is that you need to have the insurance in place before the underlying incident occurs, before you're aware of the claim. You can't get in a car accident on Monday and think you can buy your insurance on a Wednesday and think you're going to be covered, okay? I get calls, almost every day from people whose so-called house is already on fire, trying to buy the insurance to think that it would cover them. So it's very important that you get the coverage in place prior to the allegation. And it's very easy to get enrolled. The easiest way is to go online at fedsprotection.com. It takes less than 5 minutes. You can purchase in full right there. You can set up your payroll deduction right there. You can print your certificate of insurance. Last page is your reimbursement certificate. You can ask us to send you a one-page enrollment form, or you can give us a call, and we'll be happy to take your enrollment over the phone. That concludes my presentation today. I want to thank everyone for spending the few minutes with us today to learn about your professional exposures and what the F.E.D.S professional liability insurance covers. Thank you, and have a good day.